Welcome back to Artificially Informed, the podcast series that offers an in-depth look at the Florida Attorney General's Government in the Sunshine Manual 2025 edition. I'm Joel Chandler, and as always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 9, we're officially beginning our comprehensive journey into Part 2, Public Records. We'll be navigating pages 59 through 66 of your manual. Our discussion will kick off with A, scope of the Public Records Act on page 59, and then we'll immediately dive into B, what entities are covered, focusing on advisory boards, private organizations, and the introduction to the judiciary, all as outlined in your manual. Let's begin by setting the foundation with the overall reach of the Public Records Act. Segment 1, A, scope of the Public Records Act, page 59. Starting on page 59, the manual introduces us to the A scope of the Public Records Act. Think of this as the very backbone of open government here in Florida. The whole point is making sure the public has broad access to what their government is up to. The fundamental idea, the one that guides everything else, is that government records should be open for inspection by any person, unless there's a super specific reason, backed by law, to keep them quiet. This isn't just a nice thought, it's written right into Florida's Constitution. Specifically, Florida Constitution, Article 1, Section 24, establishes a constitutional right for every person to inspect or copy any public record made or received in connection with the official business of any public body, officer, or employee of the state or its counties, districts, or municipalities. This constitutional provision means the basic assumption is always in favor of openness. It's a powerful statement about your right to know. Building on that constitutional bedrock, the Florida legislature passed Section 1, 19.01, Florida statutes. This statute essentially states that it is the policy of this state that all state, county, and municipal records shall at all times be open for a personal inspection by any person. This legislative intent really hammers home that transparency is a core value here. They want to make sure the public can keep a close eye on how things are run. The courts in Florida have consistently interpreted the Public Records Act really broadly. They often say that the law should be read liberally, meaning in a way that maximizes public access. For example, a landmark case, Waite versus Florida Power and Light Company, 372 Southern 2nd, 726 Florida, 1977-79, really drove this point home. The court emphasized that the Public Records Act serves the public's right to know and promotes government accountability. It basically told us if it's not explicitly exempt, it's open. To really understand how broad this is, it's helpful to look at the legal definition of a public record itself. The manual reminds us that a public record is defined in Section 1, 19.011, subsection 12, Florida statutes, as any material, regardless of physical form, characteristics, or means of transmission, made or received pursuant to law or ordinance or in connection with the transaction of official business by any agency. This means whether it's a paper document, an email, a text message, a photo, or even a video, if it's connected to official government business, it's a public record unless a specific exemption applies. It's super comprehensive. Another important ruling that reflects this wide-ranging application is INRI report and recommendations of Judicial Management Council of Florida on privacy and electronic access to court records, 832 Southern 2nd, 712, 713, Florida 2002. This case, even though it deals with court records and electronic access, underscores that the fundamental principle of public access applies broadly across different types of government information unless a very specific, narrow exemption is in place. So, the scope of the Public Records Act means it applies widely to almost everything government agencies create or receive, with a strong intention of making those records available to you, the public. Any exceptions to this openness are typically viewed very narrowly and must be clearly spelled out by law. It's all about empowering citizens with the information they need to hold their government accountable. This foundational understanding is key as we move forward. Segment 2B, what entities are covered, advisory boards and private organizations, intro, page 60. Now let's move to page 60 and dive into B. What entities are covered, application of the Public Records Act 2. This section helps us figure out which specific organizations and groups have to follow the Public Records Act. It's not just the obvious ones like the city council or state agencies. First, let's talk about advisory boards. 1, on page 60. You might think, oh, they just give advice, so maybe they're different. But nope. Generally, if an advisory board is created by a public agency or helps a public agency carry out its duties, its records are usually subject to the Public Records Act, just like the agency it advises. This is because they are performing a governmental function or acting as an extension of a public body. The records they create in advising the public body are considered public records. Next, we look at private organizations. 2, also on page 60. This is where it gets a little more complicated. Most private companies or nonprofits aren't automatically subject to the Public Records Act, but there are specific situations where their records can become public. The law tries to prevent public agencies from outsourcing their duties to private groups just to avoid transparency. If a private organization acts on behalf of a public agency or gets substantial public money, their records might suddenly be public. It's a crucial area where the lines can get blurry and the courts often have to step in. Segment 3, B, what entities are covered? Private entities, created and contracting, part 1, page 61. Let's continue discussing private organizations and when they fall under the Public Records Act, moving to page 61. First, we have private entities created pursuant to law or by public agencies, 2A, on page 61. This applies when a private organization wasn't just hired by a government agency, but was actually created by a specific law or by a public agency itself to carry out a public purpose. Even if they're technically private, if their very existence comes from public action for a public purpose, their records are likely public. The idea is you can't create a private entity to do public work and then hide its records. Then we get into B, private entities contracting with public agencies or receiving public funds, 2.B, also on page 61. This is a really common scenario and has a couple of important tests. If a private entity contracts with a public agency or receives public funds, their records might become public. The question is, how much public involvement makes their records public? The first test for this is the 1, totality of factors test on page 61. This means courts look at all the circumstances surrounding the relationship between the private entity and the public agency. They don't just look at one thing. They consider things like 1, the level of public funding. How much money from taxpayers is going to this private entity? Is it a lot or just a little bit? 2, the nature of the function performed. Is the private entity doing something that a government agency would normally do? Is it a core government service like running a police department or a public hospital? 3, the extent of the public agency's involvement. How much control or oversight does the public agency have over the private entity's operations and records? Do they have a say in how things are run? 4, whether the private entity was created by the public agency. Was this private group specifically set up by the government to do a job? 5, whether the private entity is accountable to the public. Does it report back to the government or the public in a way that suggests it's doing public business beyond just the contract? 6, whether the public agency has a representative on the private entity's governing board. Does someone from the government sit on their board of directors or similar group? 7, Whether the private entity operates from publicly owned facilities, are they working out of a government building or using public equipment? 8. Whether the private entity exercises sovereign powers, are they doing things only a government can do, like making rules or enforcing laws? 9. Whether the private entity is essentially performing a governmental function. This is a catch-all, asking if, when you look at everything, they're basically acting like a government entity. For instance, if a private nonprofit runs a public library under contract with a county and gets significant county funding, the library's operational records, even though managed by a private group, would very likely be considered public records under this test. The case where this totality of factors test was born is News and Sun Sentinel Company versus Schwab, Twitty, and Hanser Architectural Group, Incorporated, 596 Southern 2nd, 129, Florida, 1992. This is why you'll often hear it referred to as the Schwab test. This case involved a private organization providing architectural services for the construction of a school for a county school board. The court looked at various factors, including the nature of the services performed and the public agency's involvement, to determine whether its records were public. Now, a quick note, and this is my opinion as Joel Chandler, your host, it's important to understand that when a court looks at these 9 factors in a totality of factors case, they don't necessarily have to find that each and every one of these factors applies. Instead, these factors are simply a guide, a checklist, if you will, for courts to consider when there's a question about whether a private entity should be subject to Chapter 119. They weigh them all together. However, it's also key to remember that this totality of factors test isn't even relevant in all situations. For example, if there's no question because a specific statute already makes a private entity's records public, then you don't need this test. Instances like legislative appropriations, as per Section 11.45, subsection 3, paragraph E, Florida statutes, or dues and membership contributions as covered by Section 119.01, subsection 3, Florida statutes, or even contractors with explicit contract language that's mandated by Section 119.0701, Florida statutes, directly make records public. In those cases, the totality of factors test doesn't come into play at all because the law is already clear. It's a comprehensive look at the relationship, making sure public work remains transparent, regardless of who's doing it. Segment 4B, what entities are covered? Private entities contracting, Part 2, and delegated authority, pages 63 to 64. Continuing our discussion of private entities that can be covered, we move to page 63. The second key test for B, private entities contracting with public agencies or receiving public funds, is the 2 delegation of function test on page 63. This test is a bit simpler. If a private entity is performing a function that is an integral part of a public agency's governmental operations, or one that a public agency has delegated to it, then the records related to that delegated function are considered public. It focuses on the specific action being performed. For example, if a private company is hired to conduct building inspections, a traditionally governmental function, then the records of those inspections would be public. Then on page 64, we look at C, private company delegated authority to keep certain records, 2.C. This is a very specific scenario. Even if a private company doesn't fall under the broader totality of factors or delegation of function test for its general operations, if a public agency specifically gives that private company the authority to keep records that would otherwise be public records, then those particular records remain public. The act of delegation doesn't change the public nature of the records. It's about preventing an agency from offloading records to a private entity just to make them inaccessible. Segment 5B, what entities are covered? Subcontractors and other statutory provisions. Part 1, page 65. Let's continue on page 65 with more details on private entities. We have D, subcontractors, 2.d. This is pretty straightforward. If a private entity has a contract with a public agency, and then that private entity uses a subcontractor to help them with the public work, that subcontractors' records related to the public project can also become public. The chain of public duty extends to those performing the work, even a step removed from the direct contract. The courts have noted that a private entity can't shield records from public access simply by subcontracting portions of its work that are subject to the Public Records Act. The principle is that records generated in the performance of public services, even by a subcontractor, remain public. Then we get into EE, other statutory provisions governing records of private entities, 2.e, also on page 65. Sometimes there are specific laws that directly address the records of private entities in certain contexts without needing to apply the totality of factors or delegation of function tests. One example is 1. Contract requirements, 2.e1 on page 65. This is where we need to be very clear. It's not just a nice thing for agencies to include, it's a legal requirement for many contracts. Section 1, 19.0701, subsection 2, paragraph A, Florida statutes specifically mandates the language that must be included in any contract for services entered into by a public agency in Florida. This language ensures that the contractor is bound by the public records law. The statute dictates that the following statement, or one substantially similar, must be inserted into the contract. If the contractor has questions regarding the application of Chapter 1, 19 Florida statutes to the contractor's duty to provide public records. Relating to this contract, contact the custodian of public records at the contracting agency's Department of Legal Affairs, or insert another contact method. And get this, the statute even specifies the formatting. This required language has to be in at least 12-point Times New Roman font, or in a similar font that is easily readable. This level of detail shows just how serious the legislature is about ensuring public access to records, even those held by private contractors doing public business. So it's not simply a contractual option, it's a statutory mandate to preserve transparency. Now, it's also important to understand how requests for these records are handled. You can't just go directly to the private contractor and demand records. Instead, any request for records held by the private contractor that are subject to this law must be made to the contracting agency. The agency is still the primary point of contact for the public, even for records that the contractor holds. The contractor, then, has a duty to provide those records to the agency or allow the agency to inspect them so the agency can fulfill the public records request. And if there's ever a need for an enforcement action, like if the contractor isn't complying, there are notice requirements that must be met before an enforcement action can be filed. Section 1, 19.0701, subsection 3, Florida statutes, says that if a private contractor fails to comply with a public records request, the requester must provide the agency and the contractor with 8 business days written notice of the non-compliance. Such notices must be sent by common carrier delivery service or by registered, Global Express guaranteed, or certified mail, with postage or shipping paid by the sender and with evidence of delivery, which may be in an electronic format. And a contractor who complies with a public records request within 8 business days after the notice is sent is not liable costs and attorney fees. Another point is legislative appropriation, also on page 65. If the legislature, when appropriating funds to a private entity, specifically states that the records related to those funds are public records, then they are. This is a direct legislative command making certain records public due to the use of taxpayer money. It's a clear legislative intent to ensure accountability for how public funds are spent, even when those funds go to private organizations. Segment 6B, what entities are covered? Public funds for dues and judiciary intro, page 66. To wrap up our discussion on private entities, let's look at page 66. We'll cover public funds used for dues, which is outline point 2 ETHREE in your manual on page 66. This addresses situations where a public agency pays membership dues to a private organization. If those dues come from public funds and certain conditions are met, the records of that private organization related to its activities funded by those dues could become public. It's another way the law ensures that public money doesn't disappear into a black hole without accountability. Now let's pivot to a major new category on page 66, 3, judiciary. This is a big one. Generally, the Public Records Act does not apply to the Florida judicial branch. Why not? Because the courts have their own rules and their own inherent power to manage their records. So A, Public Records Act inapplicable to judicial records, 3.A on page 66 means Chapter 119 of the Florida statutes, our main Public Records Act, doesn't directly tell the courts how to handle their records. However, that doesn't mean judicial records are secret. They are still largely public, but under a different set of rules. This brings us to B, public access to and protection of judicial branch records, Florida, R. General Prac and Judd, Administrator, 2.420 3.B on page 66. This is a rule issued by the Florida Supreme Court itself, specifically designed to govern public access to judicial branch records. It's their own version of a public records law. Within this rule, we first look at 1, scope of the rule, 3.B.1, also on page 66. This part tells us what kinds of judicial records rule 2.420 covers. It broadly applies to all records held by the judicial branch, including those of the courts, court administration, and judicial agencies. The rule aims to balance public access with the need for confidentiality in certain judicial proceedings or personal information within court files. We'll delve deeper into the specifics of judicial records in our next episode. This concludes our detailed dive into the scope of the Public Records Act and the initial categories of entities it covers, taking us through page 66 of your manual. Thanks for listening. In our next episode, episode 10, we'll continue exploring B, what entities are covered, by focusing entirely on the detailed application of the Public Records Act to the judiciary, legislature, governor and cabinet, and commissions created by the Constitution, taking us through page 72 of your manual. Until next time, remember, the truth dies in the dark, so let's leave the light on.